There is a regulation within the property law that lets someone else benefit or access your land without your permission. Let's break it down. My name's Ish, and with close to 8 decades experience as a contract expert within the commercial construction and development area, I can tell you a thing or two about the easements. And myself, having experience with transacting for properties, I can definitely come across some easement issues within the properties that I have previously transacted. So let's break it down. Firstly, what exactly is an easement? An easement is a right for another party or entity or individual to access your land without your permission. So the 6 types of easements that are within the Australian regulations that we can come across pretty often are, firstly, easement for services. So easement for services essentially gives a local authority a right, for example, a services team which is running an electrical services or stormwater or sewer under your house. So some houses across Melbourne, Sydney or the older cities have easements underneath their property which have the government assets. So these government assets at time to time may need some maintenance or repair works. So the government is going to need to access your land. Now that is called easement for services. The government's obviously going to dig down, fix that service for maintenance or repair purposes, and then obviously restructure your property and give it back to you. But making sure that if you have this easement is essential, because essentially the construction is going to be happening at your doorstep. So it's important to know whether or not that particular land has an easement, and if it does, it really depends whether or not you would want to buy that property or how it affects the value of that property. For developers out there as well, they should know that you can never build on top of this easement. So you will need and permission from the entity to build a temporary structure over the easement, but never a permanent structure, because the easement may need to be accessed by the government at some point in time. Let's look at the next one. The next one is right-of-way easement or access way easement. Now this is one of the most crucial one, and one that I came across in recent property that I looked after. So this property that I was looking to buy happened to have 2 titles. This is already an indication that it may have an access way or right-of-way easement. Let me tell you how. For example, you buy a property which is 600 square meters and it has one title for that 600 square meters, and it may have another 30 square meters as a lane, or it may have a patch of land that has a second title at 30 square meters. That title used to be a government access way to a thorough road, to the road behind you or next door to you or somewhat. There have been previous cases where there has been an established access way previously, but it has been blocked off because people have built houses behind it, so that access way is no longer required. But we have seen some incidents where people actually go to court and fight this out. So you may want to be careful before you buy the property and make sure that property only has one title, and the title is completely that property's and isn't an access way title previously. So access way essentially will give the other person or the neighbors in that area a right to walk through your property to access the property behind it, or maybe a thorough road behind it. So this is a really important one. I recently came across a property that has an access way title, and I spoke to my lawyers and then obviously found out that I definitely shouldn't be buying this. Next one, easement of support. Now, easement of support is mainly seen for commercial properties, so the developers out there should actually consider this. Easement for support can be seen where a different property or property next door to where you are developing, or the property that you are developing, may need an additional structural access to put up to support that building structurally prior to commencement of the construction. So for example, let me give you an example. For a developer who is looking to sort of buy a property which is built as a zero boundary property, which means it's built out completely to the title boundary and has no additional room, or maybe probably close to just 50 to 100 mil room as compared to their neighboring property. These properties, what happens more often than not, are situated in the CBD area of Melbourne or maybe Sydney, where they're extremely tight and they're built to the title boundary. So you're going to need to have some sort of propping or some sort of structural adequacy that's required prior to starting the construction, just to support the property next door, so that the property that you are constructing doesn't just collapse while excavating or while demolishing or something like that. So this is again a more of a commercial easement and not seen so often in the residential space, but is again an important one, and needs to be consulted with your structural engineers and to see what exactly can be done. How much is it going to cost you at the end of the day is what you're trying to figure out here. The next one would be the easement of light and air. So mainly within this easement, people look for whether or not that particular property that you're building, the neighboring property, can receive some amount of air. Usually it's more concerned with the natural lighting. So for example, if there is a house next door to you that is a single story property, and you build a property which is a double story property, and you may in some shape or form block their light somehow architecturally, this may need an easement of air or light permit. So you may have to get your architect to look into this and see whether or not you're blocking their natural light, and if you are, then you're going to need this easement permission from your neighbors, from the council, etc, etc. So a little bit of work, but then again, this is seen more in residential space, and again, it's seen where more the properties are built at zero boundary, exactly to their titles. This is not going to be seen very often in the sort of further areas that are more far out to the CBDs, but are seen more in the sort of closer inner suburbs, inner circles of the CBD areas. The next one is easement in gross, which is quite similar to the easement of services. Instead, this gives access to not the public entities, not the government entities, but the private entities such as your NBN or your Telstra or your Optus. All those optic services may need access at times, but this is actually becoming more and more less popular because these big companies are actually constructing access pits outside your title boundary, so it's not seen quite often. But another one to look out for. Maybe there are some properties that actually have this issue, but if it's not an issue, it's obviously going to be stated within your contract, so just look out for it. Another one is a very contradicting one in the sense that this particular type of easement requires a precedent set for it. So a prescriptive easement is an easement that has previously been in use and is currently being used. So this could be, again, an access way could also be called a prescriptive easement. So it does kind of fall within all these different branches of easements, but it definitely has to have a particular precedent set, which means that it has been used for the last 10 years. You can't just come up with it and be like, okay, I need to open up this access way because it used to be an access way 20 years ago and now it's not. So that's not going to fall under prescriptive easement. A prescriptive easement is something that has been functional over the years and is still being used. That's what's going to be called as a prescriptive easement, and you can't just take over this land and do whatever you like because it's actually a public access way easement which is being used for a particular sense of what it is intended to be used for. So these are the 6 types of easements that you should definitely look out for within your contract. I have come across multiple properties that have these easement issues within Sydney and Melbourne, and it's important, it's extremely imperative to look after these easements and to look out for these easements and see what exactly is within these easements. It could be a big issue which can devalue your property over the years, or it might just be a generic issue that is not going to really affect it. There are properties that are occupied currently that have service easements, for example, and they don't have really any issues because it's a very minor easement, but it's preferable and the property value will grow in price if these easements aren't within the properties in the first place. So I hope this video was helpful to you, and like I said, just look out for these easements within your contract. Thanks.